Our department, which is the Ministry of Health and Labor, our primary function is to ensure that the employers comply with the rules of the law and to make sure that each and every one also are safeguarded in terms of their safety ordinance. As a labor inspector, we go out in the field and we will do our routine inspection, which is the normal inspection every day. Apart from the routine inspection, when we do our routine inspection, we do re-inspection at the same establishment. We also have investigative inspection, whereas when we are investigating a complaint or an issue, where we have suspicion that there is people working excess hours and etc. Also, we do joint inspections that is in collaboration with the various departments, such as the immigration, ROMI, SFA, etc. My function as a labor inspector, we go out in the field and we go into the establishment. We make sure that the employers are in compliance with the laws such as the LAF, which is the foreign workers, that they have employment permits. We look at in the HoReCa sector, which is the hotels, the cafes, the restaurants. We look at the working hours to make sure that the employees at least working at least 9 hours a day, which is 8 hours is the normal working hours and 1 hour overtime. Make sure that they get their resting hours. Make sure that they work 48 hours a week. We also look at the employment, the youth employment. We make sure that the youth, which is from 15 and under, they're not working during the hours, the school hours. We make sure that those youths neither is working between 7 p.m. and 7 in the morning, to 7 in the morning. They should not be working in those areas. Also, we look at as an employee, we make sure that the employee enjoy their resting hours. When we go into the establishment, the first thing we request is the personnel list. We look to see if the employees are registered at that establishment. We look to see if the employees to give a payslip. We explain to the employees then that on the payslip, everyone should see the deductions that we made on the payslip. We look to see that they enjoy at least a resting hour, which is at least a half an hour. We, by law, working schedule is mandatory. On the working schedule, which should be posted in every establishment, we request that the employee should have the functions listed. We request that they should have the hours that they work per day listed. We request that they should have the time to start working, the time to stop working, the total hours they work per week, and it should always reflect their lunch hour. We also check into the fact to see if they are being paid at least the minimum wage and above. We also check to see if they do get their vacation paid. By law, it is mandatory also. We do check to see if they work overtime, if they are being compensated the correct percentage. As an employer, the employer needs to have a record of the overtime. The employee needs to have record of the vacation also of that employee. We also check into the safety, the health and safety of the employees. We check to see if the employee has sufficient lighting. We also check to see if the employees have sufficient urinals, sufficient toilets. We check to see if the employer is giving the employee at least water or beverage, non-alcoholic beverage. We check to see if in the construction field, if the employees have their personal safety equipments, just their hats, their shoes, their goggles, their gloves. We check to see if the employer has a fire extinguisher in case of fire. We check to see if the employees are protected against any hazard fumes. If the employer has the gears in place in case of they have to remove a spill or anything, they have their gears in place. We also check into the fact to see if case of any accident or cut or anything, that the employees has a safety kit. First aid kit, yes, a first aid kit. We check into to see if the employees, if they have to remove any harmful gases or anything, that they have their gears in place also. The employees, the employer obligation is to make sure that the workplace is always safe. Any accident that occurs in the workplace should be always reported to the Inspectorate of Health and Labor. Most time it is not reported. Once an accident is reported, the inspector goes out and makes an assessment to see what occurred in the accident, how it happened, what measure was taken. That's about it.
And on behalf of my team, complaint and dismissal, it is my task this afternoon to enlighten you about the job that we do here and the laws that we adhere to, and we would hope that when you leave here this afternoon, you will be much better informed about your labor laws and the rights as a worker. This afternoon is specifically geared towards employee and their representative. At a later time and date, sometime in the future, we will make a different session for the employer. But today is your day as an employee. Now, I can stand in front of you this afternoon and give you a long and elaborate speech about all the labor laws, but that could be quite boring. So the format that we're going to work with this afternoon is a format where we have taken real-life examples, real cases out of the society, things that we deal with on a daily basis, and we're going to present them to you as cases, and then we're going to try to solve those cases using the relevant laws that are in place and so on. Okay, at the end of the session, everybody is free to join along, ask questions, and join in and give comments about any one of the cases that we will be handling today. My esteemed colleague, Ashley Traditional, will assist in presenting the cases. Okay, we have case study number 1. Ashley, would you read the case for us, please?
Case study number 1. Employee X has been an employee of a company for 3 days. On the 3rd day, employee X calls in sick. Employer X receives a notification and wishes her well. Employee X reports back to work after 5 days of sick leave and is told she is terminated.
Okay, everyone heard the case, everyone understand what is happening? Okay, so now it's important for us to analyze what relevant articles are important in this situation. Okay? Actually, if you just go back to the case, I will be able to. Okay, it says employee has been the employee of a company for 3 days. When a person is in the employ of another person, that constitutes a work relationship. The labor law that is in place there in a work relationship would be Article 16, 13A. That would explain what a work relationship means. Okay? Now, if we go one slide further, Ashley, please. One more. Here we'll see the rights of a worker. According to Article 1613A, when there's a work relationship, the worker, the employee, has a right to wages. He has a right to perform work. Now, in every relationship that a person has rights, the person also has obligation. Everything that gives you rights also gives you obligation. The obligation of a work relationship means that you as the employee has an obligation to perform work. You cannot say, I will send my brother or my nephew today to do my job because I don't feel well. That wouldn't work. You have an obligation to perform the work that you commit yourself to personally. Okay? Now, when the two persons get together to form a work relationship, most of the time those persons know nothing about each other. This is the first time they're meeting, and therefore they're trying to establish a work relationship. Now, the employer mostly wants to protect himself against any eventuality that goes wrong in the future. How does he do that? In Article 1615, the Civil Code gives him the opportunity to install a trial period in the work relationship. A trial period is the period during which an employee enjoys no protection from the law. It means for the trial period can be 60 days long, 2 months long, and it means that during that time, any one of the parties, the employer or the employee, can end that work relationship without any legal consequences. If you go beyond the trial period, or if the trial period is not in writing, then there's no trial period and there's different consequences. Then you just cannot automatically say to the employee, I don't wish to continue anymore. There's different rules that goes into effect there. Okay? Case study number 2.
Employee X has been working for company X for 10 years without taking vacation. Employee X decides after 10 years that he will be taking 4 weeks vacation annually.
Okay. The explanation of case 1, I mentioned the Civil Code. The Civil Code is one of the sources that you can find the labor laws, but it is not the sole source of the labor laws. There are also other governmental regulations where you can find other labor laws. For instance, you would have the minimum wage regulation, the vacation regulation 1949, the severance payment regulation. Those are also other sources of the labor law. In this case, we would look at the vacation regulation to find out which law is applicable. Let's go one further, please. It says the vacation regulation says any employee that works has the rights to 3 times the amount of days that he worked per week, per year as vacation. Meaning, if a person works 5 days per week, they have the right to 15 days vacation per year. Now, if the business demands that particular person can go on vacation that particular year, the vacation can be postponed for 1 year maximum. But at the end of the second year, it is the obligation of the employer then to give the employee 2 times the amount of vacation. If 2 years pass and you did not enjoy any vacation that is longer than 2 years, will be lost. So sometimes we have situations where employees say, I didn't get no vacation for 3 years. Now I want to get my vacation for 3 years. Legally, you cannot demand any vacation that has surpassed 2 years. Okay? It is important to note the right of vacation is the right of the employee, but it is the employer that can determine when that vacation takes place. Imagine if you have a tourist business, you would say to your employee, during the high season, no one can go on vacation. And then you know as an employee, during that period of time, you cannot go on vacation. Another thing that is very important to know about vacation is that an employee cannot say to his employer, I don't want to go on vacation this year. Just pay me the money and I will continue working. Payment in lieu of vacation is against the law. The only time it is legally for you to accept money instead of vacation is when the work relationship has come to an end, because the work relationship will not be resuming. So then any money is owed to that employee will be picked up in cash. Okay? We move on to the third study.
Upon returning to work, employee X was suspended by company X because he did not report to work after the Prime Minister imposed a curfew because of a hurricane warning.
Okay, I just mentioned before the civil code.
You want me to go back?
No, let's go to the relevant article.
From this case.
From this case. The relevant article here would be Civil Code, Article 1614C. Article 1614C says, before I mention 1614C, let me tell you what Article 1614A says. Article 1614A is the general rules that gives an employee right to salary for working. The rule says no work, no pay. So you didn't work, you can't get paid. The exception to that rule is Article 1614C. Article 1614C says an employee maintains a right to salary for a relatively short period of time when he did not work, when he or she did not work because of 1, an accident or a short illness, or 2, a government regulation that has forbidden him from working at that particular time, okay? Or to fulfill a responsibility that is mandated by the government that he could not fulfill in his spare time. Now, during a hurricane, we all are familiar with that. The government often says, there's a curfew. Now, if you have to go to work and the government imposes a curfew that no one is allowed to leave home, then you can't go to work. But you maintain your rights to your salary based on Article 1614C. And that's because the general rule says that no one is allowed to leave their home. Okay? So you maintain your rights to salary, and the responsibility you do have to is to report as soon as possible to your employer the reason why you did not make it to work. Let's go to the next case, please.
Employee X has been in the employ of company X for years and has been given 3 contracts. The last contract finished on February 28, 2016. Her manager offered her a new contract which employee X refused to sign with her reason that she has a permanent working status within the company.
Okay, we all are familiar with the discussion of short-term contract in our society. Back in 2000, it was established that an employee can be given 3 contracts, and after the 3rd contract, that employee would then flow into permanent service. That is regulated in Article 1615 F8. Articles like F8 means that it's an addition that was added to the Civil Code, to the article, back in the year 2000. So the changes, it's Article 1615F, get a change, and that change they signified by 1615F8. Okay? So by 1615F8, it became possible that you work 3 contracts, and then after the 3rd contract, you would flow into permanent service. Unless you have worked for 36 months straight, more than 36 months. So you could have 2 contracts. If they together is more than 36 months, you also flow into permanent service. But if you have 3 contracts of 4 months each, or 2 months each, and you go into a 4th contract, you then flow into permanent service. Now, what does it mean, permanent service? The word permanent, people might think to interpret it as, I am here forever. That is not the case. The difference between permanent service and contractual service is at the end of the contract, you can be sent home. When you are in permanent service and the employer wants to end the work relationship with you, they would have to request permission from this department. That is the difference between permanent work relationship and contractual work relationship. Okay? Okay, case number 5.
Employee X forgot his uniform hat at home. He was issued a $40 fine from his employer. The following week, he missed the mandatory training and was fined $100. Employee X missed 3 radio calls and was fined $150.
This is a very interesting part in the labor law. This gives the employer the opportunity to impose a fine on the employee. And that is regulated in 1613S. Because the employer has the right to impose a fine on the employee for whatever infringement that is stipulated at the beginning of the work relationship or in the general regulations of the employer, there are also very strict rules that the employer must adhere to. And some of those rules are, the fines must be in writing. So an employer cannot tell his employee, I'm going to fine you today $40 for not having your uniform hat on or whatever reason. 2, it must contain an accurate statement of the destination of the fine. So the employer cannot say, I fine you $40 and that's the end of the story. There must be some indication of what is going to happen with that $40. And one thing that cannot happen with it is that the fines will not be used to the advantage of the employer or the person who is authorized to impose that fine on the employee. For logical reasons, if the fines were able to be used to the benefit of the employer, then the employer can adjust his payroll by imposing fines. Or the person who is imposing the fines on the employer behalf can also influence the budget of employer's payroll. And that is not allowed to happen. Okay? And there's one very strict condition to imposing fines, is that no fine may be imposed upon an employee that will mean that that employee will have to pay more than 1 day wage per week. So a situation where an employer tells his employee, you won't be paid for 6 days, that's totally wrong, because 1613 limits the amount of the fine to 1 day maximum per week. Okay? Here also comes the responsibility of the worker. Because your employer cannot impose any fine at will on you, you know you have that responsibility to conduct yourself as a good employee should. What that means, I would advise you to contact your union and they would help you understand how a good employee should conduct himself. Case number 6.
Employee X works for company X for 40 years. Management offered employee X a termination settlement. Employee X refuses settlement and continued working for company X. 3 months later, employee X died on the job. Mrs. X reports to the employer X to collect severance pay on behalf of her deceased spouse.
Okay? Everyone understand exactly what happened here? So this particular person worked for 40 years. Okay? Worked for 40 years, was offered a payout at the end of 40 years and refused. Continued working and died 3 months after. Okay? Now his wife goes and asks, what about severance pay? My husband has worked 40 years long for this company. I come to find out how much money you had here for him. The sad truth of that question is, the civil ordinance makes it clear under what condition an employee is entitled to severance pay. Article 1 explains what is severance pay. Severance pay is a one-time payment for years of service in monies. Okay? It doesn't matter if an employee is on a contract or he's in permanent service. Anyone working more than 1 year is entitled to severance pay. But to get severance pay, you must lose your job for a reason that is beyond your control. So it is not so that you can manipulate getting your severance pay. If you are, for instance, a good cook and your employer is happy with you, and you say, look, I want to end the work relationship because somebody else is offering me more money elsewhere, the employer will tell you, well, I'm probably sorry to lose you, but bye-bye. He don't owe you no severance pay under those circumstances. It must be a reason that you have no control of. For instance, hard economic times, business gone bankrupt, something like that would entitle you to severance pay. Now, in the example, we said that the employee passed away. He had worked 40 years and then passed away. I never mentioned that that was one reason for severance pay. When you passes away, your next to kin, so wife and children, do not have any claim on your employer unless that claim was already established before you died. Meaning, if the work relationship had come to an end and it was established, yes, John has a claim of $30,000 on the employer, but the employer did not manage to write a check yet, and John passes away, then the heirs of John can claim that money. But if John worked for 40 years and before he had a claim on severance pay he passed away, then unfortunately his heirs cannot claim any severance pay. Okay?
Case study 7. After work on Monday, employee X was rushed to the medical center where she delivered a bouncing baby boy. Employer sent her flowers and a card stating, "Congratulations and enjoy your maternity leave. See you back to work in 6 weeks."
Okay? I think the day of the woman was this week, somewhere in this week. Okay? Now, now, it's interesting, label registration this week. Article 1614 CA. Okay, yes. The rights to pregnancy leave and maternity leave. For you gentlemen who think it's one thing, it is two different things. Pregnancy leave is when the baby is still on the inside. The lady is still pregnant. She has a right to pregnancy leave. When the baby comes out, the baby is born, you have maternity leave. That is time that the mother gets to spend with the baby. Okay? Right now, we're discussing maternity leave. But Parliament got to work that out yet. Okay? That's for the fathers. But we ain't there yet. Now, the pregnancy leave is 6 weeks before delivery, and maternity leave is 6 weeks after delivery. Put them together, it's 3 months of leave. Okay? During the leave, that leave, maternity, pregnancy leave, the lady is entitled to 100% of her salary. Not 80%, 100% of her salary. Okay, the exception to that could be what happens if, as in our case, you work up until delivery. So, as we say, the lady left work and had to be rushed to the hospital where she delivered a baby boy. So there's no opportunity for pregnancy leave. In a case like that, the law limits the maternity leave to not 3 months, but 8 weeks. So instead of she getting the whole 3 months after the delivery, she get maximum 8 weeks after the delivery. Okay? The responsibility of the worker is to keep her employer up to date with her medical situation and when she's expected to return back to work. Because there could be cases also where maternity leave, they could go back into sick leave based on whatever illness. But then the salary drops back to 80%. Only until the end of the maternity leave, it stays at 100%. Okay? Case number 8.
Employee X has been working for Company X for the past 6 years. For the 1st of January 2012, Company X outsourced the employees of his company to the placement agency without informing them. At the end of the month, Employee X salary was paid by the placement agency. Employee X has been receiving salary slips for the last 4 years from the placement agency. Employee X has been on sick leave for the last 4 months. Upon returning to work, Employee X was given a termination letter from the placement agency.
Okay, this is a phenomenon that has been taking place more and more in our society. The rising of these employment agencies everywhere. And some of the things that we are seeing happening is that employees go to their work and then all of a sudden they're confronted by employers telling them, go and report to a placement agency, you now work for them, or you go to them to collect your salary. Okay? Now, you remember when we started out this session, we started with Article 1613A. Okay? And 1613A talks about the work relationship between two persons, where one person commits himself to perform work in the employ of another person. Okay? So that is what you do as an employee. And you have to be careful now when you have your employer and your employer sending you by a third party to perform work or to collect your salary. The logical question that you should then ask your employer is, based on what law, what contract, what agreement? I don't have no agreement with any employment agency, so therefore I should not report anything to any employer or collect anything from any employees. Okay?
The case up to
I understand. Okay? Everybody understand that one? Okay? Could we go ahead again?
Yeah.
Okay, we go ahead. Okay,
The one in
Go
city.
forward.
we go forward. Okay. As I was saying, the rights of the worker, Article 2 Labor Regulation 2000 does not recognize the employment agency as an employer. Okay? Here, an employment agency is more viewed as a headhunter. You are looking for an employee to do a particular job. An employment agency could find that person for you, or could fit you a person for a temporary situation. For instance, while the lady went on pregnancy, maternity leave, an employment agency could find you a replacement. But it is not so that an employment agency could become your full employer. Okay? Your responsibility as an employee is to be aware of that, to be conscious of that, because what happens now, if you sign an agreement with the employment agency, then you get a conflict with 1630A, where you had a relationship with your employer. 10 years later, for whatever reason, you go and sign on to an employment agency for the same time, the same hours. So you kind of automatically then releases your employer from his obligations towards you. And that is the trap you have to be very cautious of. Okay?
Case study 9. Employee X has been working for company X for the last 6 months. Employee X has never received a pay slip from his employer. Whenever employee X requests his pay slip, he is told that he is not able to receive pay slip until he has a permanent worker status within the company.
Okay. The Civil Code, Article 1614 P8. Remember I said, anything you see with a second letter behind it means it's an addition to the old Civil Code. Okay? So before 2000, there was no demand of a pay slip in the Civil Code. That was added by 1614 P8 back in 2000. With the changes of the labor regulation 2000, the demands of the pay slip was added. Now, what is a pay slip? A pay slip is not simply a receipt. Okay? Some people show up and say, look, this is my pay slip. when you see this, receive from this company $2,000. That is not a pay slip. A pay slip is supposed to indicate the following. It's supposed to mention the name of the employee, the name of the company the employee works for, the salary of the employee, both hourly and monthly or bi-weekly, how he collects it. It's supposed to specifically mention which period that payslip is for. If the payslip does not meet those requirements, then it does not qualify as a payslip, and then the labor inspectorate will get in contact with the employer and make sure that that payslip is brought into line with the relevant labor resignation. Ladies and gentlemen, I think we have reached to the end of our presentation, and the opportunity for questions now is with you. I want to mention the responsibilities before we go into question. The responsibilities of the Department of Labor as it pertains to employees. Now, when you have a conflict situation with your employer and you feel that your employer does not treat you well, you are welcome to file a complaint with the Labor Department. However, you must understand, and we try to make it as clear as possible to employees, that the Labor Department is not your lawyer. The Labor Department is not the lawyer of the employees, nor of the employers. We have a role to mediate and to make everybody aware of the playing rules in the labor field. We make you aware of all the rules that are applicable, and we give advice to your employer how to deal with your particular situation. Your employer has no obligation to follow our advice. Neither do we have any authority to, how you say that? To sanction your employer for not accepting our advice. If your employer chooses not to go along with our advice, then we have to give you a second advice, which if we are sure or we agree that you stand right in the advice that we give you, then we direct you to social services that can grant you legal assistance in taking your issue to the judge, to courts. But it is always the relationship, the parties, so the employee that takes his employer to courts, not the Labor Department. The Labor Department is not a party to the labor conflict. The issue is between employer and employee. We guide you to the right steps to achieve justice.